guidance and your wisdom. Bless in particular the chair and the members of the committee. And please, Lord, allow us to ensure that all decisions that we take are to the benefit of your kingdom. His mercy I ask in Jesus' name. Amen.
Your mother would be proud of you. Thank you very much for that. So, members, there's not much in terms of a welcome and opening remarks. I think I laid the foundation at the last meeting. There are some housekeeping matters that I would just raise now, since we're going to go into presentations and I may be out for a while. So I would say let's defer that and go to the reading and confirmation of the minutes held on March 24th. Minutes are not very long, they're pretty straightforward. I'm hoping that everyone would have gotten the opportunity to run through them. And therefore I ask if there's any corrections or anything that needs to be amended in the minutes as we have them for the meeting of March 24th, 2021. Let me say welcome to those members who are not at the first meeting. Welcome them to the committee. And again, thank them for their kind offer to serve on this committee, which we all know the importance of it in relation to what is transpiring in this new world of technology. So for the minutes, I would ask if there's anyone that has any amendments or corrections to the minutes as we have them in our files. Is Minister Lester Morgan on? So if there's no amendments or corrections, could I ask for the confirmation of the minutes of the 24th? Can I ask Minister Green and Senator Morris if they could move and second?
So moved, Chair.
Seconded, Chair.
Thank you so much. Matters arising from the minutes. There is not much that I see there outside of some of the issues that I will raise now before we go into the agenda for today, which is the MSET overview of the current legislation and JustCert's presentation. There has been about 2 or 3 requests for extensions that have come to me through the committee. I think if my memory serves me correct, it is PSOJ, JPS, and I think 1 or 2 others seeking an extension of the time, as which you'll recall that was for today. The deadline was for today, the 21st. So I would like to put to the membership that we could extend for 2 more weeks to allow for those entities and others to be able to take part in terms of written submissions and presentations to the committee. Based on the emails that I saw, I think that it is widely accepted for the extension. I don't know if anybody has any objection to that. Any other committee members? All right, and if not, then I would say definitively that would be the 2 week would be the final extension. Well, the first and final extension, because I think based on who has been written to, which the clerk has advised that Jamaica Cyber Incident Response Team JustCert, which we're hearing from today, Communications, Forensic and Cybercrime Unit of the JCF, Jamaica Technology and Digital Alliance, formerly Jamaica Computer Society, and the Jamaica Information Technology and Service Alliance, the Office of the Director of Public Prosecutions, Jamaica Bar Association, Major Organized Crime and Anti-Corruption Agency, Financial Services Commission, Jamaica Bankers Association, Private Sector Organization of Jamaica, Simtai Consulting Limited. Those are some of those who have been written to formally from the committee. To date, we have not received any submissions, but I suspect that those will be coming once, of course, the extension is granted. And I also recall at the last meeting, a member of the committee asked representatives from MSET to provide information at the next meeting on the bug bounties, ethical hacking, security research, and whistleblowing. So I would expect that would be dealt with in their presentation. So basically, those are the only matters arising. I don't know if any member has any comments on that they would like to share. All right, so we have today for discussion, as I said before, an overview from Ministry of Science, Energy and Technology on the Cybercrimes Act 2015. And then we also have, I think, just Lieutenant Colonel Sterling, who will come after in relation to a presentation from them. So without further ado, I'd ask the Ministry of Science, Energy and Technology, I think CTD Joaquin Murray, are you leading on this?
Yes, Minister, I am.
Morning to you. All
Morning.
right, so I'm going to try and get back in as quickly as possible, but I'd ask Minister Green to just take the chair for me. But I'm on, and the meeting hasn't started yet, so I will be in the presentation until such time as the PM calls me. Thank you very much. Go ahead, Ms. Murray.
Thank you, Chairman. Morning, members of the committee, morning, colleagues on the call, as well as media representatives. I am just going to pause a little to share my screen. If you'll give me a moment, please. All right, can you confirm whether you're seeing my screen?
Yes, I am for sure.
Yes, Ms.
All right. Thank you, members. So as was said, the ministry will be providing an overview of the Cybercrimes Act of 2015. It is our intention as we make this presentation to look at these agenda items: background, key definitions, substantive offenses, procedural provisions, and the jurisdiction of the legislation. With respect to the background, members will recall in the chairman's opening remarks at the last meeting that it was indicated that this piece of legislation, certainly the 2015 version that we're looking at, is not the first Cybercrimes Act that has been promulgated in Jamaica. We actually had one promulgated on March 16, 2010, and that 2010 Act called for its review after the expiration of 2 years from its commencement date. The review of the Act led to its repeal and replacement with the Act that the committee has now been charged with reviewing the operations of, and it was promulgated on December 21, 2015. The 2010 Act review led to the following, and these are the major outcomes: the introduction of new offenses, and the inclusion of a forfeiture provision, and increases in all monetary penalties and custodial sentences. So moving to some of the key definitions, these are not all the definitions in the legislation, but these are singled out for the purposes of the overview. The first one we're going to look at is that relating to computer, which is defined in the legislation as any device or group of interconnected or related devices, one or more of which processes data automatically pursuant to a program. It also includes data storage facility or electronic communication systems that are directly related to that device or group of connected or interrelated devices. The next definition that we're going to look at is that of computer service. Computer service includes provision of access to any computer or to any function of a computer, computer output, data processing, and the storage or retrieval of any program or data. With respect to damage, damage is defined in the legislation as meaning any impairment to a computer or to the integrity or availability of data that would result in economic loss, threats to public health or safety, that would cause or threaten physical damage to the computer itself, or modify or impair the medical examination, diagnosis, treatment, or cure of persons, and of course would threaten physical injury or death to any person. Additionally, the legislation defines data to include materials stored electronically in whatever form, the whole or part of a computer program, and any representation of information or concepts in a form suitable for use in a computer. With respect to electronic communications system, that is defined as a system for creating, generating, sending, receiving, storing, and displaying, or otherwise processing electronic documents or data. And the legislation also defines the word key, and key in relation to data or other computer output includes codes, passwords, algorithms, biometric identifier, gestures that would allow access to the data or output or facilitates putting the data or output into intelligible form. So those are just a few of the key definitions as outlined in the legislation. And we'll now move to the substantive offenses established by the legislation. So before commencing a review of the substantive offenses under the Act, it is useful to note that there is no agreed position on the definition of what constitutes computer or cybercrime. For the purposes of this review of the Act, however, I have adopted a categorization which divides cybercrime or computer-related crime into three categories. Firstly, where the computer may be incidental to an offense and may have significant evidential value. So if we think about it, we're talking about a situation where you may have, for example, a drug dealer and the information relating to his drug dealing is stored on a computer, and that computer becomes incidental to the offense and is significant as evidential value. Then secondly, we have the instance where the computer may be a tool or instrument for committing offenses, some of which are of a traditional form or nature, for example, fraud. And then thirdly, we have instances where the computer may be the target of an offense itself. And so with those three categories, we'll see that the offenses that are outlined in the legislation fall into at least two of those categories. So the first offense as created under Section 3 is unauthorized access. The offense contemplates that the individual, and I'll just read it, knowingly obtaining for one's self or another any unauthorized access to program or data held in a computer. We note the fines and terms of imprisonment on summary conviction, 3 million, ranging from 3 million to 5 million, depending on whether it's a first offense, damages caused, or it's a subsequent or second offense. The term of imprisonment ranging from 3 to 5 years. And then of course, if it's on indictment, then a fine generally, with the term of imprisonment ranging from 7 to 15 years. This offense, unauthorized access, contemplates that the individual simply accesses the program or data held in a computer, or having access actually obtains information by either downloading a file or viewing the information on a screen. The offense, and just to note, the offense reflects provisions of Article 1 of the Convention on Cybercrime, or the Budapest Convention. And I'll just make the point here that a lot of what is contained in our legislation really mirrors and or elaborates on or was guided by what has been established in the Convention on Cybercrime, even though Jamaica is not a party to that treaty. The legislation defines obtaining access, and in section 2, subsection 2, obtaining access is defined as meaning causing a computer to perform any function that alters or erases the program or data, copies or moves the program or data to another storage medium, or causes a program or data to be executed. Additionally, access is obtained when the computer causes the program or the data to be output from the computer itself. Right. The other definition that we want to look at in the context of this particular section is that relating to unauthorized access. So section 2.4 defines unauthorized access as access, modification, and use as occurring when a person is not himself entitled to control the access, does not have consent from any person who is so entitled, and is not acting pursuant to the Cybercrimes Act itself or the Interception of Communications Act. So unauthorized access can be considered in two ways, where the individual has no right or authority to access the computer and is essentially considered an outsider or a trespasser. The access is commonly referred to as hacking, and of course can be effected through different ways, to include malwares. The second situation is where there is the individual who may have some authorization to access a computer system, but goes beyond that authorization, thereby effectively exceeding the authority that he has been given. And that person you would consider to be an insider. So that person does have some access, or is allowed some access, but has exceeded his or her authorization. The next offense created by section 4 is the access with intent to commit or facilitate an offense. Section 4 creates the offense of accessing any program or data held in a computer to commit or facilitate the commission of an offense. Here, the computer is being used as a tool, as the objective or intent of an intrusion is to further a separate crime, for example, fraud. With respect to access with intent to commit, we note that the offense may be committed even if the commission of the offense is impossible, and it is immaterial whether the access is with or without authorization. Of course, the idea here being that you can't authorize unlawful acts, something that is unlawful. And the offense is committed and it is immaterial also whether the offense is committed at the same time access is secured. So in other words, if access is gained and then the other offense is committed at a later date, the offense is still created or committed. The next offense created by section 5 is unauthorized modification of the content of a computer. Here, the person with intent and without authorization damages, deletes, or erases, alters, or changes computer data. And this could be effected by inputting malicious codes or viruses that can threaten the integrity or use of data or programs. The fines, as outlined, are similar to ones that we've looked at previously, ranging from 3 million to 5 million, depending on whether it's a first offense or a second or subsequent offense. The term of imprisonment, again, 3 to 5 years, and on indictment, terms of imprisonment ranging from 7 to 15 years. With respect to modification of the content of any computer, That is defined by Section 2, subsection 6 of the legislation, and modification of the contents of any computer is defined as occurring when the functions are either altered or erased, any program is added to the contents of the computer, and any acts occur which impairs the computer's normal operation. Just to make a point here on this slide, it is immaterial whether the modification is or is intended to be permanent or temporary. The next offense created by Section 6 is unauthorized interception of computer function or service. Here, the offenses created are knowingly securing unauthorized access to any computer for the purpose of obtaining directly or indirectly any computer service, or, my apologies, without authorization, directly or indirectly intercepts or causes to be intercepted any function of a computer. With respect to the interception, this offense, you will note, is akin to the traditional concept of tapping and recording oral telephone conversations between persons. The distinction, of course, here being that the tapping is being done with respect to a computer. We note that for the offense to be committed, the interception must be carried out intentionally and without authorization. The section defines intercepting to include listening to, viewing, or recording a function of a computer, or acquiring the substance, meaning, or purport of any such function. And continuing on the section, also what we see is that this section does not apply to any interception permitted under the provisions of the Interception of Communications Act. And of course, that would be in the interest of national security or crime prevention. The next offense is created by Section 7, and it is unauthorized obstruction of operation of a computer. So an offense is created where an individual intentionally and without right or authorization, without justification or excuse, performs an act or acts that seriously hinder the functioning of a computer. And examples of such acts include denial of access or denial of service attacks. Denial of service attack is a malicious attempt to interrupt or suspend the availability of a computer or network for its users. And this is usually done by flooding the machine with irrelevant internet traffic. So the offenses created here, again, the fines and terms of imprisonment are akin to offenses that would have previously reviewed. The next offense is created, or offenses are created under Section 8, and I'll just point out to the members that computer-related fraud or forgery was one of the new provisions or offenses that would have been added to the legislation by virtue of the review of the 2010 legislation. We have two offenses here created: computer-related fraud and computer-related forgery. The offenses are derived from Article 8 of the Budapest Convention and are aimed at criminalizing deliberate, dishonest manipulation of data for gain. With respect to computer-related fraud, here the individual fraudulently, that is dishonestly or deceitfully, inputs, alters, deletes, suppresses data, or interferes with the function of a computer with the intention of procuring an advantage, that is, putting himself in a favorable position by causing loss of property to another person. It is to be noted that even if the advantage was not achieved, it is sufficient that there was an intent to gain an advantage. Examples of this would include, for example, online credit card fraud. And we note also that the fraudulent acts are sometimes effected through phishing emails. With respect to computer-related forgery, here the individual intentionally inputs, alters, deletes, suppresses data with the intent that the data be considered or acted upon as if it were authentic. It is important for the members to note that while computer-related fraud requires loss of property, computer-related forgery does not. And while computer-related forgery requires the manipulation of data so that it is acted upon as if it were the original, computer-related fraud does not. We see here slightly different fines ranging from 4 to 5 million and 4 to 5 years with respect to the term of imprisonment, and where it is under summary where it's on summary conviction, and then of course on indictment, the fines generally. However, members' attention. Inserted further to the review of the 2010 Act is malicious communications. There are three ingredients, all of which must exist before a prosecution can be initiated under this section. And this, members will note, was confirmed in guidelines for prosecuting cases involving malicious communications issued by the Office of the Director of Public Prosecutions in 2017. So the three elements are as follows: that a person used a computer to send data to another person, constitutes a threat or is menacing in nature, and that the data, which is either obscene or a threat or menacing in nature, or all three, or a combination of the three, was sent with the intention to harass any person or cause harm or the apprehension of harm to any person or property. With respect to element 1, which treats with the sending of data, while the word send is not defined in the Act, it has been construed as including publication generally, and that can be publication to a social media site, for example. With respect to element 2, which looks at the nature of the data or message that is sent, the word obscene is also not defined, but applying the common law definition, it would speak to data of a sexual nature or data which offends against society's morality and tends to deprave or corrupt minds open to immoral influences. With respect to the definition of menace, the common law definition would also be applicable, so that data is considered menacing if it tends to threaten with harm or danger or create fear or apprehension of harm or danger. With respect to element 3, which speaks to the intention to harass or cause harm or apprehension of harm, we see that the mens rea, or the state of mind that is required, is intent, so that recklessness or negligence concerning whether the sending of the data would cause harm is insufficient. The fines here are similar to the fines for computer-related fraud and forgery, 4 years, 5 years, 10 years, 15, 20 years, and $4 million, up to $5 million. Continuing on malicious communication, however, the offense, we know that the offense is committed regardless of whether the actual recipient is or is not the person to whom the offender intended to send the data, and that there has been a carve-out or an exception that has been made for communication relating to industrial action in the course of an industrial dispute. Before I move to, just to close out on this offense, it's important to note that the data that is sent has to be more than simply offensive, controversial, unpopular, or defamatory. Section 9 does not criminalize sending defamatory content, false content, or fake news. Therefore, these are not sufficient reasons to engage the criminal law, certainly in relation to this particular section. And so other avenues would have to be sought by persons who are aggrieved. With respect to section 10, The offense created here is in respect of the manufacturing, distribution, or use of devices that have been designed or adapted for the purpose of committing a cybercrime. And these devices include passwords or codes. The fines are similar to fines that we have looked at before for malicious communication, as well as computer-related fraud and forgery. Section 11 creates the offense of offenses related to protected computers, and it simply provides that committing an offense under sections 3 to 10, which would have been all the offenses that we reviewed up to this point, where the computer concerned is a protected computer, carries with it a fine on indictment and 25 years. The Act does define what it means by computer, by a protected computer, and essentially the list is a fairly long list, but it would apply to a protected computer is one that is considered that or would be used for security, defense, or international relations, law enforcement, confidential educational material, the protection of public safety, whether through or is the police, fire brigade, medical services, computers too that provide services regarding communications, infrastructure, banking and financial service, public utilities, public transportation, and public infrastructure. So essentially what this particular offense does is that where the computer that is either being used as a tool or is either accessed or modified in an unauthorized way is a protected computer, then that just compounds matters for the offender, and the term of imprisonment can be up to 25 years. The next offense is section 12, and this speaks to, well, essentially inciting. It provides that intentionally inciting, attempting, aiding or abetting the commission of any of the offense is an offense itself, conspiring with another to commit the offense, and essentially what would happen here by virtue of the fines and term of imprisonment is that the person would be liable for the monetary penalty or the term of imprisonment that would apply to that substantive offense that was committed. So that persons who are who conspire with the others are treated in a similar way. Section 13 treats with actions prejudicing investigation, and where a person discloses information that is likely to prejudice an investigation or falsifies, conceals, destroys, or otherwise disposes of or causes any of these things to happen, that person can be guilty of an offense. And the fine here is $3 million on conviction before a parish court judge, or 3 years for a term of imprisonment, and then on indictment, a fine or 10 years, up to 10 years imprisonment. With respect to actions prejudicing investigations, the Act outlines that in certain instances, an offense is not considered to have been committed. So the offense is not committed if there is knowledge or reason, there's no knowledge or reasonable grounds to believe that the disclosure is likely to prejudice the investigation. The disclosure is made in the exercise of or in compliance with a requirement imposed under the Act. The disclosure is made in connection with legal proceedings or contemplated legal proceedings or the giving of legal advice. There is no knowledge or suspicion that the documents are relevant to the investigation, or there is no intention to conceal any facts disclosed by the documents for any official carrying out the investigation. So we now move to section 14, which speaks to offenses by bodies corporate. And here the offense is that, well, the section provides that where a director, manager, or secretary is found to have connived in the commission of or failed to exercise due diligence to prevent the commission of the offense, then they can be fined up to $2 million on conviction before a parish court judge, or a term of imprisonment not exceeding 2 years, or a fine on conviction on indictment and a term of imprisonment not exceeding 6 years. Section 15 treats with compensation and provides that where a person is convicted of an offense, the court may, in the same proceedings, order the person to pay a fixed sum as compensation to any person who has suffered loss as a result of the commission of the offense. So this would conclude the substantive offenses under the legislation. And I'm going to now respond to the questions or the question that was asked by one of the members at the last meeting in relation to bug bounty, ethical hacking, security research. So bug bounty is a reward offered to a person who identifies an error or vulnerability in a computer program or a system. And the reward is usually offered by IT companies to drive product improvement and to, of course, get more interaction from end users or clients. I think we know what ethical hacking is, penetration or pen testing, involving breaking into computers and devices to test an organization's defenses. And then with respect to security research, this involves investigating existing types of malware, analyzing their capabilities, and attempting to predict new forms of malware to develop appropriate security responses. We note too that security researchers may also reverse engineer malware or test security systems. So based on the definitions of bug bounty, ethical hacking, and security research, one could argue that activities carried out by bug hunters are conducted with the consent of the IT companies and therefore would not be considered unauthorized access for the purpose of the Act. Members would recall that Section 2.4 defines unauthorized access, modification, and use as occurring when a person does not have consent from any person who is entitled to give that consent. With respect to ethical hacking and security research, the lawfulness of these activities turn also on the issue of authorization. And so to the extent that the intrusion or the access has been authorized and consent has been given, then they would not, certainly in my reading of the legislation, run afoul of the Act. I'll turn now to the procedural provisions for purposes of investigation and enforcement, and just note that the Act makes provision for certain investigative tools to be utilized by law enforcement. Section 17 treats with preservation of data, and what we see here is that due to the intangible and transient nature of data, Section 17 enables a constable to order the preservation of specified data that is stored in a computer or storage device to prevent the data from being destroyed, whether intentionally or accidentally, or modified so as to render it inaccessible. We'll see here that what is required is that a written notice be issued to the person in possession or control to ensure, requesting that they ensure that the data is preserved, and the constable, of course, needs to be satisfied that the data is reasonably required for a criminal investigation, and there are reasonable grounds for suspecting that the data may be destroyed or rendered inaccessible. The notice issued the preservation notice is to specify, among other things, the requirements to be complied with for the preservation of the data, as well as the period for which the data is to be preserved, not exceeding 60 days. However, the legislation does allow for extension upon an application to a parish court judge. There are offenses created in respect of preservation of data, so failing without reasonable excuse to comply with a requirement imposed by notice, or making a statement that the person knows to be false or misleading, or recklessly making a statement that is false or misleading in a material particular. And the fine attached to that and term of imprisonment, $3 million before a parish court judge, a term not exceeding 3 years, a fine on conviction on indictment, and a term of imprisonment not exceeding 7 years. Another tool afforded law enforcement is search and seizure warrants. That's created under Section 18, or provided for under Section 18. And essentially, Section 18 enables the authorities to search and seize computer material, including data, a computer or any part thereof, or a data storage medium, for example, drives and disks, and of course, to make copies of the data. The warrant, of course, has to be issued by a parish court judge, having been satisfied that there are reasonable grounds to suspect that at any particular location, there is material that is relevant as evidence in proving an offense, or has been acquired by a person for or in the commission of an offense, or as a result of the commission of an offense. The warrant authorizes the constable to enter the place specified in the warrant to search for and seize computer material. And it is noted that the power to seize includes the power to make and retain a copy of the data, including by using on-site equipment, render inaccessible or remove data in a computer, and take a printout or otherwise reproduce or capture the output of any computer data. With respect to Section 19, there is an obligation that is placed on the person executing the warrant to make a list of what has been seized or rendered inaccessible, and to give a copy of the list to the person named in the warrant or the occupier of the premises on which the warrant is executed. The person who has, well, a copy of the data may be requested by the person, of course, and that must be given. And unless it is that the executing officer believes that in the circumstances a copy, well, they have to give a list, provided that they've satisfied themselves that it won't constitute or facilitate the commission of a criminal offense, and it won't prejudice essentially the investigation that is ongoing, or any criminal proceedings that may be brought regarding any investigation. The person who executes a warrant is required to take all reasonable steps to preserve the computer material seized or rendered inaccessible. And then Section 19 also creates some offenses here: failing to take reasonable steps to preserve the computer material that is seized or rendered inaccessible, or where the computer material is seized or rendered inaccessible, the person uses the data for another purpose, or discloses the data other than for the purpose of the act. And that fine is a $3 million, potentially a $3 million fine, or in default of the payment of the fine, up to 3 years term of imprisonment. Section 20 treats with forfeiture, and essentially allows the court, on an application by the Director of Public Prosecutions, to order the forfeiture of any computer material used in the commission of the offense if the court is satisfied that the person owns the computer material, the owner of the computer material permitted it to be used in the committing of offense, or the circumstances are such that it is just to do so. Just jumping a little, the DPP is required to notify the owner of the computer material of the seizure and the intention to apply for a forfeiture order and the grounds therefore. Where the DPP is unable to ascertain who the owner is, then of course the legislation requires that a publication be made in a daily newspaper of the intention to apply for a forfeiture order. The notice is to be published 30 days prior to the application, and any person having a claim to any seized computer material, of course, may appear at the hearing and show cause why the order should not be made. Of course, if no one appears, then it would be assumed that the material has been abandoned. And any person who is prejudiced by a forfeiture order may apply within 30 days after, but not exceeding 6 months. And where the court is satisfied that in the circumstances, it can revoke or vary the order that would have been issued, and it may require the person to pay such charges in respect of storage, maintenance, expenses, etc. The last tool that we're going to look at that has been made available to law enforcement is production orders, and Section 21 of the legislation treats with that. The section enables the competent authorities to order a person to submit specified stored computer data. The order may be required where the person refuses to hand over data, or the person has certain confidentiality obligations to its clients and may require a court order. So here, upon application made by a constable, of course, before a parish court judge, they may make an order requiring a person in possession or control of the data to produce it in intelligible form to the constable. The person who is given effect to the order, of course, may use any key in his possession to obtain access, and is taken to have produced the data or output if they disclose the keys, and we would have looked at the definition of keys before to include passwords, etc., or codes. So if that is disclosed, then the order is deemed to have been given effect to. The legislation, or this provision, Section 20, allows for what we call ancillary orders to be made. And it can be included in the production order, or it can be, at the time the production order is being applied for, it can be made, an application for an ancillary order can be made subsequent to. Essentially, the section enables the constable to apply to a parish court where there is reasonable grounds to believe that a key to any data or other computer output is in the possession of any other person. So the ancillary orders here are really treated with the production of keys to enable access to data that might, to the material that has been seized and or produced. Just jumping a little bit. So the ancillary order should describe the data or other computer output to which it relates, specify the time by which the order is to be complied with, set out the production that is required by the order and the form and manner in which it is to be made. The provision also, that's the section, also outlines, sorry, my apologies. The section also outlines some matters that have to be taken into account in granting an ancillary order. And suppose one can say that because of the potential for the invasion of privacy, these considerations are important. So for example, they have to think about the extent and nature of any information to which the key is also a key, any adverse effect that compliance might have on any lawful business carried on by the person to whom the order is addressed, and require only such production as is proportionate to what is sought to be achieved, as of course allowing for production in such manner as would result in the putting of the information in intelligible form other than by disclosure of the key itself. So just one last point on ancillary orders. Where an ancillary order is addressed to a person who is not in possession or is incapable of producing, then that person shall be taken to have complied with the order if he produces any key that is in his or her possession. Compliance with these orders is considered sufficient if the addressee produces only those keys, which is sufficient to enable access to the data or output or computer output and to put it into intelligible form. Now, there are certain obligations that are imposed on the constable in respect of keys that are delivered, and the constable is under an obligation to ensure that the key produced is used to obtain access to only data concerning the order, that the key is stored securely for the period retained, and any records of the key are destroyed as soon as they are no longer needed. And of course, that the key is not made available to persons who ought not to have it. And so there's a limited number of persons and copies that are made available to anyone else. An offense is created by virtue of, there are two offenses. 2115, failing to make arrangement for securing a key obtained pursuant to an ancillary order, that's $1 million fine up to 1 year term of imprisonment. And then section 21(6), subsection 16 and 17 treats with failure to comply with the requirement imposed by an order, and that can be either an ancillary or production order without reasonable excuse. And the fine there is up to $4 million or 4 years terms of imprisonment, and or a fine on conviction or on indictment or up to 7 years. I'm almost at the end. The last thing that I'm going to be looking at is jurisdiction. We note from section 22 that the Act recognizes the common law principle of territoriality by virtue of the location of the act or conduct. We note here that the Act applies to conduct occurring in wholly or partly in Jamaica. However, the principle of territoriality is widened by extending the locus of the crime to conduct occurring wholly outside Jamaica, but affecting a computer or data wholly or partly in Jamaica or on board a Jamaican ship or aircraft. Additionally, the Act artificially extends jurisdiction beyond Jamaica's physical borders by applying same to conduct occurring wholly or partly on board a Jamaican ship or aircraft. And then jurisdiction is further extended via the extraterritorial principle of active nationality, which claims jurisdiction based on the nationality of the perpetrator. So we know that the Act applies to conduct occurring outside Jamaica, but attributable to a Jamaican national. And the Jamaican national is defined in the legislation to mean a citizen of Jamaica, someone that has connection with Jamaica or is a native or resident of Jamaica, and of course, a company or other legal entity constituted in Jamaica pursuant to the laws of Jamaica. So that would bring me to the end of the provisions in respect of the legislation, but I have one more comment to make in respect of the question that was asked at the last meeting, and that is in respect of whether the Act treats with whistleblowing. So based on what we've seen or heard, the Act does not address the issue of whistleblowing by employees to speak up or about cybersecurity vulnerabilities. We note, though, that there is a Protected Disclosure Whistleblower Act of 2011, which is aimed at facilitating the making of disclosures to improper conduct in the public interest, and of course, with a view to protecting employees from occupational detriment, which is defined in that legislation. However, when we look at the definition of improper conduct, there are only maybe 2 instances where matters of a cyber crime or cyber criminal nature could fall, and I've outlined them here. Criminal, where the conduct is a criminal offense, or where the conduct is likely to threaten the health and the safety of a person. So in this, in summary, with respect to whistleblowing, the Cybercrimes Act does not treat with it. And we're not entirely sure, outside of the instances outlined in Bullet 3, whether the Protected Disclosures Whistleblower Act of 2011 would enable whistleblowing in respect of cybersecurity vulnerabilities. That ends the presentation. Thank you very much, and I am open to questions.
All right, I don't think Minister Vaz has come back as yet. I had indicated to him, as he had indicated, he is in another meeting, but I had indicated he had asked to indicate when the presentation was finished. Let me commend you, CTD, on a very comprehensive presentation, and the floor is now open for questions. So if there are any questions, now would be the time.
Chairman, if I may.
Yes, Senator Samuel.
Thanks again. I'd like to also associate myself with the comments you made, and commendations also to Ms. Murray and her team. I don't want to dive into questions. No, I would just ask that if possible, if we could ensure that Ms. Murray avails herself to the committee in approximately 2 weeks. I certainly missed the first meeting, but there are a few points that she raised I would like the time to go through. It was such an extensive presentation. I would like to have the opportunity to go through some of the points she made, even at the next sitting, if possible, Chairman.
Yeah, I don't see a challenge with that, Minister Samuel. I think that's a good suggestion. It is a lot to digest, and it is not only a significant act, but also a lot of constituent parts. So I'm sure CTD will be with us for all of this journey. So if it is that we want to take time, and at the next meeting, we could have Ms. Murray and the team there to answer some questions that the committee may have. So I don't see a challenge with that, Minister.
Thank you, Chairman, and thanks again, Ms. Murray.
You're welcome, Senator, Minister.
But with that said, if there are questions, pressing questions now, yeah, I hear Minister.
Hi, I had asked a question via email. I don't know if you had gotten it. And it's not related to your presentation. Has the ministry, as the Director of Public Prosecution, been requested to give comments? Okay.
It is my understanding that they have.
All right. Thank you very much.
Yeah, and they have. I can confirm that Minister Morgan that they have been asked to give comments.
Thank you very much, Chairman.
Chair, can I ask? I came in. I apologize for joining late, and I would have come in at the end of the presentation. But having looked at it, I think it was a very extensive presentation that provides great clarity to the legislation itself. But I would like to ask Murray and our team whether or not there are areas that have been identified in the legislation that would require priority as for amendments. And if so, if they can at any point in time represent those areas that would have been of concern to us that we need to look at. That would be my question, Chair.
I might respond, Chair, to the member Gail. We haven't, as a ministry, undertaken a review of the cybercrimes legislation ourselves. We would have been detained over the last couple of years with one piece of legislation that was considered critical, and that is the Data Protection Act. We note, however, that because there is a built-in review of the legislation, that this review that is being conducted by the committee would certainly bring to the ministry's attention any shortcomings of the legislation. The opportunity is taken to point out that we have not, as a ministry, received any formal comments or comments from anyone in respect of the working of the legislation. And so we see this sitting and this, well, certainly the work of this committee has been critical to, one, hearing what the concerns are, if there are any, hear from the likes of the Director of Public Prosecution or the Office of the Director of Public Prosecution and law enforcement as to how the legislation is working. Certainly, we wouldn't want to fix anything that is not broken. And so we are like the members are happy to have this opportunity to hear from private and public sector organizations and entities regarding how the legislation is working and how it can be improved. And because we will be supporting the committee, of course, then we would share our views on anything that is raised as a recommendation.
Thank you. If I'm permitted, Chair, just a follow-up question, because this legislation would have been enacted in 2010. And so there would have been a vast change in terms of the environment and the type of cyber crimes that would have taken place. Now, are there any other comparable legislations that you could drag our attention to that would be a part of assisting us in this review?
We certainly believe, and this is a 2015 legislation.
Sorry, 2015.
Member, right?
Sorry,
that the review that took place prior, that would have informed this legislation, would have taken a look at the landscape. We would have been informed by, as I mentioned early in my presentation, the single treaty on cybercrime. In the review of that of the 2010 legislation, and I would think in a similar way when the committee is reviewing this legislation, it will be mindful that that it needs to ensure a couple of things. One, that we remain as technology or neutral as possible, that whatever we do is in keeping with international practice, because as members know, cybercrime is a trans-border crime. Some of the challenges that law enforcement encounters in relation to cybercrime is when you have an offense committed in one country and there is under mutual legal assistance treaties or agreements and or extradition treaties or agreements, the requesting country is unable to further their investigation because the offense is not one in the country from which you're seeking, support. So we are mindful that we certainly wouldn't want a piece of legislation that would cover and would aid in prosecutors, investigators in the performance of their work without delineating every single thing. And as you said, and correctly said, that the cybercrime evolves, and what always happens is that the technology evolves beyond the legislation, and the legislation is trying to keep up. So we think no. We've had persons comment on our legislation and the robustness of it, whether it is aligned to, for example, the Budapest Convention, and we've been told certainly that our legislation is pretty much on par with others. As I indicated, this is an opportunity for us, certainly by the committee, to see how it can be strengthened, having heard once you've heard from both public and private sector entities.
Thank you, Ms. Murray. Thank you, Chair.
Thank you, Senator Gale, and very, very, very good questions. Okay, so if are there any other questions? Again, I believe that the team will make itself available if you want to peruse the document and the presentation, digest it, and then at our next meeting, the team will still be here. So if you have questions then and there should be no challenge. So if you have no more questions, no, then we will basically bring the meeting to a close. There are some housekeeping matters that I will go into to address on behalf of the chair. So final call. Are there any more questions at this moment? I see Senator Longmore. You can go.
Thank you, Chair. I'm kind of between 2 or 3 meetings, and I'm not sure if I missed it, but I have a little concern, and I'm not sure exactly where it may obtain as we proceed, and it may come up later on. Maybe around slide 30 when we're talking around protected computers, etc. But as we go into the virtual world of telemedicine and teletherapy, we are in different forums particularly concerned around the provisions legally for patients to be engaged, their privacy, the practitioner's responsibility, and there is great need for guidance for these practitioners as to how to legally go about, and particularly in my field, telepsychiatry, because we are so ethically bound with respect to patient confidentiality, et cetera, et cetera. And I'm not sure exactly where that may obtain in the presentation, because like I said, I'm actually between two meetings at the same time. But that is something that is of grave concern to us, and I would like to get some direction on that, if it's such as possible at this time. Thank you.
All right, team, any response?
Chair, if I might
Yes.
respond to 2 things before I take Member Longmore's question, just to indicate, Chair, that we actually have another presentation from the ministry. That's from the head of the
cyber response.
Jamaica.
Right. Okay, I thought
Right.
it was next meeting. No problem. Okay, great.
No.
So after this, we'll go into that.
Right. So, but in response to Member Longmore's question, to the extent that it involves intrusion or access to compute
for data protection.
A protected computer. And what that section 11 does is really to say that where it involves medical information, then there is.
Sorry, Minister Green, I think your microphone is still on. Yeah. Mm-hmm.
Right. Where there's intrusion or access unauthorized in respect of any computer or data on a computer, the offenses are created from section 3 up to section 9. What the section 11 does is it says that where the computer is used for particular purposes, to include medical or what we call protect public safety, and things that are essential, then those issues, those computers, or let me rephrase it, the potential for imprisonment and a fine is greater because of the type of computer that has been accessed. With respect to the obligations of medical professionals in the realm of the electronic or the cyberspace, there I think are several pieces of legislation that you'd have to probably look at along with the Cybercrimes Act to include the data protection legislation. You'd have to then be guided by that as well, bearing in mind that the Data Protection Act speaks to how you treat with personal information as well as sensitive personal information, which would include medical information, and the responsibility of medical practitioners as data controllers to ensure that there are technical and organizational measures that are taken to secure the data. So there are obligations there, and I think that is a piece of legislation that might be most useful, certainly from where I sit. That might be most useful to practitioners.
Okay, so this would be in conjunction with the Public Health Act, the Medical Council that relates to medical registration, et cetera, et cetera?
I can't speak to those things. I can't to those pieces of legislation, but I know for a fact, based on where we sit and what we have portfolio responsibility for, that the Data Protection Act would be one of those things that medical practitioners would have to bear in mind.
Right. Okay. All right. Thank you. Thank you. You're muted, Minister. You're muted.
Ah, boy, you know. All right, thank you, Senator. Yeah, I was saying, good question. We're going to go into the next presentation, which is the Jamaica Cyber Incident Response Team. And I remember, I think it was Senator Morgan who had made a specific request last meeting in relation to a number of matters. So we're going to have a presentation now from the Jamaica Cyber Incident Response Team, and we'll take questions after. So over to you.
Thank you, Chair. Good morning to the members. Just give me a few seconds while I share my screen. So in following on to the presentation done by the CTD, the presentation of the Cyber Incident Response Team is really aimed at giving a snapshot of where we are as far as cybercrimes in today's world and taking it down a notch to what is happening in the Jamaican space. As far as the outline, what I intend to do this morning is to take a very short but hopefully comprehensive look at what is happening globally. I will then look at some of the regional trends that we are grappling with as cyber incident response practitioners. Following that, I will look at how things are in Jamaica, and I will give a brief rundown of what we've had to respond to here at the CERT for 2020. I will then look at how cybercrime is actually trending worldwide and what we're facing as far as the hyperdigitization brought onto us by the pandemic. We'll then look at what we are doing and how Jamaica is postured to respond to some of these threats, as well as some of the challenges, and then I'll summarize. So as far as the global outlook for cyber threats, what we are seeing is that in cyberspace, the nature of adversaries is actually very dynamic and is evolving on a daily basis. We have gone away from the nature of how we attribute cyber crimes. And so adversaries, through their sophistication and the level of obfuscation of what they do within cyberspace, it becomes very difficult to pin something onto a nation state. Now, if you're following what is happening, you will recognize that the latest massive hack that took place with SolarWinds, the US government has actually attributed that to the Russian administration. However, what really we're facing in cyberspace is what we call advanced persistent threat actors. And these sometimes are backed by nation states, and sometimes they're just really part of cyber gangs. And they actually have the wherewithal to push the level of threat and their activities in cyberspace in some instances to extents that governments can't even respond to in a very timely way. Now, if we take it down from the advanced persistent threat actors, what we have are persons who are really now hacking sometimes just for sport. And this is facilitated significantly by the advances in technology, the cheapness with which this technology can be accessed, and the proliferation of new vectors for committing these crimes. So what we have is a combination of adversaries within cyberspace that are now equipped in such a way that they can mount very sophisticated attacks that are almost adaptive to the environment they're trying to get into. And a lot of times governments are unable to keep pace with this change in technology. How we see that being countered is through significant information sharing, particularly among incident response teams from different regions. And what this does is allow for the shared experiences, particularly lessons learned, to be used in countering these vulnerability exploits. Threat intelligence is also one way that we're seeking to get a grip on the menace that we face. However, not many entities in cyberspace can maintain a persistent threat intelligence gathering. And so what we seek to do is to co-opt exercises that are meant to train, to exercise, and to test the ability of incident response teams to deal with some of the challenges that we face. Additionally, recognizing that a fair amount of the activities within cyberspace that threaten civil law and also the rule of law and just how society has been brought up is the lack of regulations that can actually be enforced. And so policies and the rigor of those policies that are enacted are really meant to complement the regulations. What you find is that with the exception of the Budapest Convention, which seeks to criminalize the use of information technology and cyberspace for the commissions of crime, we have the Christchurch call for action, which took place after the bombings in Christchurch a couple of years ago. And that seeks to take the responsible nature of behavior in cyberspace one step further, where it seeks to ask that nation states, as part of responsible cyber behavior, ensure that within the remit of their cyberspace, they remove those things that incite violence, particularly extremist comments and radicalized movements. However, here in Jamaica and the Caribbean, we're not particularly affected by these sorts of utterances. So as we seek to bring some amount of order to cyberspace, we have to be cognizant of the fact that there are three distinct internets out there. The open or surface web is what we use on a day-to-day basis, and this is where our Google or Bing actually operates. The largest number of internet users never go beyond this. Then we have the deep web, which really is where those databases that contain confidential and or proprietary data are hosted, as well as intranets that are geared towards the provision of particular services, including those related to defense and aerospace. Now, to get to the deep web, there is a requirement to have specific sets of credentials. And so it becomes a little less accessible to the average person. The dark web, however, is where there is really, if you want to look at it, it is the wild west of the internet and cyberspace, where web pages housed on the dark web, they're not indexed. You use virtual traffic tunnels, which are always encrypted, and traditional browsers will not allow you to access sites on the dark web. Now, a lot of countries in treating with the dark web have actually outlawed its access by individuals within their borders. However, we do not have that same sort of restriction. And so as the technology becomes available to make browsing to the dark web and deep web a lot easier, we're faced with significant challenges to what we would consider to be our normal day-to-day cybercrimes. What we saw coming out of 2020 was a significant increase, sometimes in the range of 1,000-fold increase in pandemic-related phishing. And this is where persons in our countries in response to the pandemic created a lot of tracking and contact tracing applications that sometimes were not as secure as they really should be. And so what you found was that threat actors within cyberspace actually capitalized on this. And with respect to the fear caused by the pandemic, as well as the opportunities caused by the different modalities, some of which required remote work, they actually ramped up the phishing attacks that they had. Ransomware also took the spotlight for some of the year, because what we found was that gangs were now being formed as cyber actors started to group their activities. And what they would do is, from the phishing attacks, they would share the data and information collected, and then these would be used to mount ransomware attacks. We also saw a significant increase in the compromise of business emails. And what this meant was that the email servers for corporations were actually compromised, and then those corporations were used to send other malicious emails out. This created significant challenges for corporations, as not many were prepared to deal with the magnitude on which the attacks occurred. With the profusion of mobile devices, it was really just a matter of time before cyber criminals changed their tact. And so whilst they were traditionally geared towards going after the computer and the physical servers, they modified the manner in which they were doing their attacks to target mobile devices. And a slew of malware for mobile devices, or madware, was actually something that took a significant chunk of the year for incident response practitioners. Cyber activism versus ethical hacking. Cyber activism took a significant uptick, particularly in the Asian subcontinent, where, again, with the difficulty to attribute these attacks to any particular nation states, advanced persistent threat actors with ties to some countries in the Eastern European and Asian blocs were actually attributed with taking a number of these systems, particularly in India and Japan, out of commission just because of their intent, as it were, to bring the fact that there are vulnerabilities that were not being remediated to the light. Here in Jamaica, we had our own jam COVID situation, and that was just one aspect of cyber activism, or ethical hacking, if you want to put it down to that. The advent of artificial intelligence and the Internet of Things, the smart watches, the smart cars, this facilitated a significant increase in the attack surface that was available, and it was significantly exploited by cyber actors throughout cyberspace. Additionally, what we saw were supply chain attacks being perpetrated against some companies. And for the second time in a decade, the Iranian nuclear facility at Nance was attacked using a supply chain scenario. We see a significant increase in the way in which card not present fraud is taking place. And this really means that your card does not need to be stolen or lost. The information around this access just needs to be had by persons who are not meant to have it, and they can then do transactions on your cards, whether they be debit or credit. The banks in particular saw a significant rise where these were concerned. Data breaches, with a significant amount of it attributed to insider malfeasance and errors, took place throughout the year. And we saw, with the rise of cryptocurrencies and the value of cryptocurrencies, a significant increase in cryptojacking, where particularly the North Koreans were actually accused of jacking a lot of cryptocurrency sites with the aim of getting Bitcoins that could be then converted to regular cash. Most of these attacks were targeted, and some of them were just targets of opportunity. What we saw was a significant increase in what we call the man in the middle or the watering hole attacks. And these were primarily geared at those persons who opted to work from home or were first forced to work from home. The ability to pursue some of these criminal elements once the crime was committed became a lot more problematic because of their use of encrypted communication platforms. And this continues to be a challenge because even though the device or the incident may be uncovered, the nature of the communication being encrypted means that the content of that communication is oftentimes not readily accessible. I've already spoken to Bitcoin popularity, but what it has meant is that as we move away from paper money or hard currency and digital currency become more commonplace, the value of Bitcoins will continue to rise. And the new concept of non-fungible tokens is something that is also being used or being targeted by malicious actors within cyberspace. The distributed denial of service attacks that we saw were not as numerous as prior years, as most of the threat that came out of 2020 were surrounding ransomware as well as business email compromise. Social engineering continues, and the level of ingenuity and creativity is just really always increasing. So what we find is that utilizing some of the popular websites, persons were actually asked to provide different pieces of information. These were then put together to create phishing emails, and the data was then used to mount ransomware attacks. As the workforce and most education institutions moved away from the brick and mortar structures and became more distributed, what we found was a lot of remote desktop protocol attacks where the persons working from home whose only way back into the corporation was through VPNs or other encrypted tunnels, they were the ones now being attacked. And when you look at it, if you can get into somebody's network using legitimate credentials, whether they were stolen, you got them through phishing or any other dishonest means, then it was easier for you to do whatever it is that you wanted to do within the network without being necessarily identified. This CTD touched on this, and just to say that with respect to bug bounty, it is really big business. The companies that are out there that actually run these programs, they pay out mega bucks each year. And what we find is that implicit or explicitly, they actually give consent for these testing or penetration of their systems. What we saw last year was a 63% in hacker reported vulnerabilities. And so the real trend towards activism and ethical hacking is something that is taking on a really new meaning. And when you look at the fact that some of these hacking courses that either to cost thousands of US dollars, you can get bundles of them now for under $50 US. And once you're dedicated enough, you can actually go through and train yourself. The outlook for this year is for more money to be spent, really. And it goes from just individual corporations running their own programs to Switzerland that now has a national program where they seek to ensure that everything that the government puts up, and for those companies that run critical infrastructure, they are tested not only by in-house testers, but also by anyone who want to use a platform to test their products. Regionally, what we saw was a significant increase in cyber extortion. And this is where employees, however they were compromised, whether it was by phishing or spoofing, were being extorted by cyber criminals to commit acts of crime within their corporations. We saw a significant case of this with the First Caribbean International Bank, where in the Eastern Caribbean, they suffered a number of these instances. We also have cyber-enabled criminal activity. And if you look even here locally, a lot of our regular crimes against the person or common law, crimes at common law are enabled through communication using smartphones or other communication devices. Online fraud, we also saw a significant increase in this, and the ability to actually pursue the fraudsters became a little bit more challenging given the encrypted nature of their communication. Irresponsible cyber behavior, and this ranges from just profanity and obscene postings to revenge porn all the way through to cyberbullying. We saw a significant increase across the region, with Costa Rica trending the highest where this was concerned. Locally, this is what our national cyber ecosystem looks like. With the Office of the Cabinet and the National Security Council, you have the Ministry of National Security with their Cyber Intelligence and Incident Response branch, as well as the JCF Communication Forensics and Cyber Division. Now, MSET has GESCERT, and we deal with threat research, forensics, and incident response. MOCA, having gotten independent agency status, also is able to deal with threat research, forensics, and incident response, but they are focused mainly on the criminal side of the fence. Where the energy sector is concerned, with the exception of JPS, there isn't much there with respect to cybersecurity or incident response. The telcos have a fairly robust incident response setup, and their cybersecurity departments are fairly well established given that they're multinationals. The financial sector, there is a fair amount of monitoring that takes place. However, the existence of a sectoral type response capability that is nuanced to the crimes that will come out of the financial sector does not exist. The criminal justice system, there is a cyber crimes unit in the office of the DPP. However, the staffing and the ability to actually manage and marshal the evidence, from the sequestering of artifacts, the analysis of those artifacts, the preparation and presentation of the evidence at a prosecution to the ascribing of punishment, is something that also creates a bit of a challenge. And so there's room for improvement there. The private sector on a whole, there is a fair amount of resources that exist out there. We have corporations such as Simtai and TTEC that are available to do some of this sort of penetration testing and or incident response. However, what we find is that the micro and small enterprises, they are not really catered to. And to this end, GESCERT, from where it sits within government, actually responds on demand to not only government entities, but also corporate entities that report incidents, as well as individuals, given the fledgling nature of cyber incident response in country. Last year, we fielded over 136 reported incidents. And one of the greatest challenges we faced was that a number of reported incidents, the victims aborted midway the process. And there are varying reasons for this, but a large proportion of it was really that once they got to seeing what was required to see the matter through to, say, for example, a prosecution, they just did not follow through with it. And for them, it was easier to just simply delete a profile and start a new one, or change an email address. Doesn't really address the challenges, but for them, it meant that they didn't really have to play the victim card, and this was a challenge. More than 70% of that 136 cases was referred to the JCF through their Communication Forensics and Cyber Division, as there was deemed to be a prosecutable nature to the offense reported. The top three categories that we saw were abusive content, which really ranged right across the continuum of abusive content that you have out there. Now, the CTD spoke to the fact that libelous actions within cyberspace is not really criminalized. However, if we take the view that irresponsible behavior can be made to be enforced within the Jamaican cyberspace, then we really need to look at how we can get that to be enforced by the JCF and or any other agency that is so empowered. Impersonation was a key element of what we saw as far as online fraud, where entire websites or social media pages were cloned and persons unsuspecting or otherwise were asked to purchase things from these platforms. Once the monies were paid into legitimately opened accounts within our financial sector, the sites were then taken down and the perpetrators disappeared. We saw a significant number of revenge porn cases on just about every social media platform out there, as well as through WhatsApp. And this is something that we have dealt with as a case in point, and that was a successful prosecution and something that we can see greater enforcement of going forward should be something that comes out of the review of this legislation. We saw a significant jump in the value of cybercrime, where the high-end items that were being sold from fake sites and social media pages amounted to significant sums, whereas murders and even some of the robberies, some of the high-profile ones of persons leaving the banks with large sums of cash being trailed were enabled by the use of communication devices or computers, and this became significant throughout the year. Cyber activism and ethical hacking, we've already looked at the legal aspects of it, but what we're seeing is an uptick in the willingness of persons in Jamaica to do this sort of thing. The fact is that without the approval of the entity owning the resource that is facing the internet, it still becomes a crime. And one of the recommended way is to actually do the due diligence, especially for ethical hacking and security research, for the entities offering these courses to work with the companies having internet-facing resources to ensure that the matter of scope, as well as the parameters of doing the penetration testing, the ethical hacking, are understood up front so that there are no cause on the back end for persons to commit a crime unwittingly or knowingly. We saw some ransomware activity locally. There were public and private sector entities that were affected. And one of the challenges we saw was with the remediation, where it was simply a matter of scrub and replace. Now, what that does, it prevents response entities like JASERT from being able to examine and analyze any artifacts. And so the ability to build a database of vulnerabilities based on those exploits was not possible. And so that is something that we can look at strengthening as well. Through our continued efforts at strengthening our ability to respond, we've now a persistent means of scanning the horizon for the Jamaican cyberspace. And what we see is that we're not so much affected by advanced persistent threat actors or nation states, but more so by persons who, under the guise of ethical hacking or security research, are really trying to break into entities. Now, one word of caution here is that within Jamaica's cyberspace, the actors are not necessarily postured in their cybersecurity to deal with some of these challenges. And so when their entities are broken into under whatever guise, it puts them at risk, it puts the clients at risks. And what it does is that their ability, especially for the smaller entities, to respond to those breaches become problematic. The new technologies, as I mentioned before, continue to buoy the number of cyber incidents that we're facing. And this really is creating a challenge. What we've done as a response is to seek to understand through our partnerships with other certs, particularly those in the Eastern Bloc, where zero-day events in particular are concerned, so that we get a very small window within which we can respond, but it's a window nonetheless. And we're able to understand how these technologies are being utilized, given that we're not necessarily the victim of some of these new methods of cyber crime. And we are able to build our response capabilities around that. As far as cybercrime and cyber-enabled crime, the improved workings with MOCA and the CFCD out of the JCF has allowed us to treat with a number of reports that hitherto may have been just a statistic. And we've seen where we've gotten some good response from both entities, and we continue to improve that relationship. Information sharing, we've started with primarily the public sector entities, as well as some private sector entities, particularly the telcos and those who are responsible for national critical infrastructure. Now, while we have not codified what the national critical infrastructure sector really entails in its entirety, we are working with those ones that really just stand out. And we are able to get a fair bit of information sharing going now with the academic community, particularly with the University of Technology. What we're working on is the creation of a virtual sandbox capability to allow their graduate students doing cybersecurity research to work on pre-production copies of software and systems that are going to be put on the internet, rather than working on the production copies and creating a legal challenge. What we see as well is that with respect to the regulatory and policy response to some of these challenges, the larger entities, they have policies in place, they have response capabilities in place. And so the challenge we continue to face is really with the micro and small entities and the ability to respond to them. Having looked at what is really happening globally, regionally, and locally, we must take into consideration that the advent of the pandemic has really broadened the attack surface for cyber criminals. And what we see is that less and less persons are actually doing the traditional hacking as a way of getting into cybercrime, but really they're now being motivated by money and espionage, as well as primarily some of the challenges with radical thought and radicalization. It doesn't really get up to cyber war in the consideration, because state-sponsored actors, it's very difficult to attribute the acts committed in cyberspace to them. But what we find is more often than not that a lot of the advanced persistent threat actors have some linkage back to some nation state. Supply chain and logistics continue to be a soft target because some of the downstream activities are not really very secure. And as we move towards a more connected environment, our smart devices are not built around security and oftentimes create vulnerabilities for us. As we move into virtualization and we create what we term software-defined or internet-based networks, then oftentimes the responsibility for securing these networks are taken out of the client's hands and the providers of these services are not necessarily providing the best security for the service they're offering. 5G will bring with it increased opportunities for both growth and economic development, as well as for cybercrimes. And as we move through the spectrum and get into the use of 5G enabled devices, we're going to find that cybercrimes, the attack surface for it will increase, because the speed and the availability of these devices will actually increase the ability for them to be compromised. You can buy anything as a service from a cloud provider, and this is sometimes going to be problematic because the matter of jurisdiction comes into play, as well as what rules exist where your data resides at rest when you buy a service from these hyperscale cloud service providers. And always you'll have the human factor. And with this age of digitization, as far as the modalities for education and working, it is really a critical enabler or a critical factor in how fast and how wide the attack surface increases. As the attack surface increases, what we find is that there are different vectors, different modalities that these cyber criminals are using to attack different resources in cyberspace. The number of endpoints or individuals with devices connecting back to resources has increased tremendously with the work from home regimen that exists, as well as the mixed modalities for education. What we also find is that cloud security risks have increased as a lot more entities are moving their operations from their usual brick and mortar premises into the cloud. And the behavior of persons as they move out of the restrictions of a traditional building and into their homes is creating significant challenges for cybersecurity practitioners and opportunities for nefarious cyber actors. Ransomware continues to be a factor in how these attacks are executed. And what we have are gangs of cyber criminals who actually share their ransomware activities online. Phishing and business email compromise continue to be used, and the distributed security perimeter now is a challenge as persons move out of the traditional office space and work from home. This becomes a bit of a challenge. Less and less are the attack payloads requiring that a file be executed, and more it's just the environment that is being targeted. And if this environment isn't particularly secure, then it creates a significant vector for the delivery of payloads that can be used to compromise a network. Passwords continue to suffer from brute force and dictionary attacks, and the old threats of just your out and out hacking, sometimes just for sport, is something that will not go away but becomes more sophisticated as time passes. Locally, these are the lines of effort that we seek to counter cybercrimes. As far as threat response, there's a JCF through its CFCD, there's MOCA, and there's JASCERT. There are very limited assets to respond to cybercrime in Jamaica, and predominantly they exist within JASCERT and MOCA. The intelligence support comes primarily from MOCA and JASCERT, and as far as remediation, there is the non-criminal side of it, where we assist companies to get back up and running based on their own disaster recovery processes, or we assist where there is none. The criminal justice system is really managed by the JCF through CFCD and MOCA, and is coordinated through the Office of the Director of Public Prosecutions. Given the prevalence of cybercrime and the widening of the cyber attack surface, as well as the increase in the vectors of attack, what we find in terms of challenges are the legal requirements. We cannot legislate every single irresponsible act in cyberspace. And so where legislation exists, the enforcement of it becomes critical in terms of a deterrence. And when the reported acts are not really pursued through to prosecution, then the deterrent effect is lost. As far as regulations, it is good to have these, and whether it is through standards or policies, once it is not onerous on the clientele within the constituency, then it helps. And what we really try to do is to encourage entities to self-regulate as best as is possible. Create your business continuity plan, create your disaster recovery plan, be risk-based in how your cybersecurity resources are postured, and be willing to share and coordinate in the response to events. Now, resourcing is always going to be a challenge, and certainly here at Just Cert, that continues to be something that we grapple with. However, based on the reported incidents and the priority of response, we do what we can. Cooperation is improving, but there's still a far way to go, as because of confidentiality and other requirements within the private sector, as well as just an absence of trust, there is very little cooperation on breaches and or assessed vulnerability. The challenge with this is that where vulnerabilities are uncovered, they're not reported. And so a vulnerability that, if reported, could have been remediated or mitigated in another entity, that entity suffers the same exploit because there is that level of or low level of sharing. As far as responsible cyber behavior, we continue to push the public education and awareness portion of the requirements of the 2015 cybersecurity strategy and seek to build cyber hygiene among our constituents. Whistleblowing was actually spoken to, but what we find is that with the non-disclosure of the existence of vulnerabilities and or the suffering of a breach being criminalized in the Cybercrimes Act, there really isn't a provision for whistleblowing to take place as far as cybersecurity is concerned within the current context of both the Cybercrimes Act and the Disclosure Act of 2011, because essentially the act of not disclosing the fact that you have a vulnerability or you have suffered a breach is not criminal. And security research, we've spoken to that. There is room for it. However, the way to avoid the legalese is just to do the due diligence, get the consent of the entity with which you wish to work, and work through it. And then the whole aspect of fear, the fear of being labeled a victim, but for both individuals and corporations, continue to be a significant challenge that we face. When we look at our horizon scan for, say, a 7-day period, we're seeing upwards of 10, 12,000 incidents of vulnerabilities or breaches. But when we look at the reported incidents for that same period, sometimes we have less than 10. And so this shows that with less than a 1% of these breaches and vulnerabilities being reported, there is still a long way to go as far as overcoming the fear of being labeled a victim of a cybercrime and reporting it so that the necessary analysis and remediation can take place. The database of events and responses can be built, and we can become more robust and mature in our cybersecurity posturing. So in summary, what we see across the global scene, members chair, is that cybercrime continues to increase in sophistication, and the level of obfuscation makes it difficult to attribute these crimes. with respect to nation states, while you can associate some hacking groups in cyberspace to links with nation states, you can't really attribute what they do to the states. Regionally, what we're seeing is a lot of the less persistent threats being exploited, and more of an uptake on exploiting the individuals within companies rather than trying to break into the companies. And nationally, what we're seeing is that as government seeks to shore up its ability to respond to cyber incidents, we're having a lot more response from government entities, but we would like to see corporations play a greater role in reporting these vulnerabilities, in reporting these breaches, so that there can be a greater cooperation and coordination as we seek to build a more robust response capability. The general population, we have to continue along the lines of public education and awareness, and especially when we look at how much the attack surface has increased, certainly here, when we look at the mixed modalities for work and education, there are significant challenges that we face. These challenges are not insurmountable, and certainly the review of this piece of legislation will go far way in helping us to mitigate those as we move forward. That concludes the presentation. Chair, members, I am open to questions.
Thank you very much. I'm back, Lieutenant Colonel. Very, very insightful, especially for those of us who heard the entire presentation. So thank you, Chair. Thank you, Minister Green. I wasn't there for the MSET presentation, but I have it in writing, so I will go through it again. But I'm sure there are some questions and comments in relation to this insightful presentation by Mr. Sterling. So the floor is open.
Mr. Chairman, I have my hand up. May I go ahead?
Sure, Mr. Bunting, sure.
Lieutenant Colonel, when we go, if you go back to your slide, the page that had the top, or the slide rather, that had the top three categories: abusive content, impersonation, and revenge porn. You said that most of the complainants dropped the case. They decided not to pursue the case, although they made an initial report. And I can understand, especially from putting myself in a victim's perspective, that the burden of pursuing the case to a conclusion, apart from an emotional burden on them, it might have a significant financial burden as well. If they have to employ a lawyer, a cyber forensic expert, it really might just put the hurdle too high, the bar too high on top of everything else. Having received the original complaint and collecting the evidence, can the police, the JCF, not pursue this, the criminal offense on its own? Or in every case, we need the complainant to follow through? That's question one. And I'll just ask both questions together for efficiency. The second has to do with ethical hacking. Now, ethical hacking is, what should I say? It's sensitive. On the one hand, it can have a benefit, because if the hacker exposes the vulnerability of a site or a system and brings it to the attention of the owner of the site, and which allows the owner to correct whatever that vulnerability is, and therefore prevent some
more serious damage being done, then they're providing a service. And I'm assuming that they are not doing any exposure or benefiting, that this ethical hacker is not benefiting in any way personally from it. But at the same time, my understanding is that if that person exposes the breach or brings it to the attention of the owner, they may very well be putting themselves at peril for, you know, what should I say, for exploiting that vulnerability or for going into the system to determine that vulnerability. Should we have some provision that would allow for that within a certain framework? For example, that the person, the hacker, does not publicize the vulnerability until it has been corrected by the owner of the site or the system. So those are the two questions. Thank you.
Chair, through you to the member, with respect to the first question, the matter is really a legal one, and I am by no extent a legal luminary. Certainly, if the matter reported does not have a criminal undertone to it and is not referred to the JCF, what we do here at JCERT is to pursue the matter to a conclusion, and we keep the complainant in the loop until the matter is resolved. Now, with respect to our jurisprudence, the need to have a complainant, especially when you look at common law, I don't think this appears with the Cybercrimes Act. And so with respect to pursuing the matter, certainly at the very least, what we can seek to do is to increase the awareness of persons that, you know, it really oftentimes does not require the ability to, of your own pocket, get that sort of legal representation. And I'm not sure if the Legal Aid Council can actually provide lawyers with a technical background, but certainly it is something that we can look at. And in the same way that the matter has been raised in other quarters with respect to whether or not the complainant needs to be present, we can look at it. What happens when the matter is dropped is that the ability to actually see how the crime was perpetrated, and not just the fact that it was, is lost to both the JCF and MOCA on the criminal side and to us. And so the ability to treat with subsequent crimes become a bit of a challenge. And so in the considerations that this Joint Select Committee will do, what can be done is to look at whether or not that is something that we can seek to encourage or even write into the legislation without making it a bit onerous on the part of the victim or the alleged victim of the cybercrime. Additionally, when we look at the cybercrime and cybersecurity space internationally, what other countries have been able to do and do very successfully is to be able to issue what are called emergency directives, which are binding to all entities within a particular jurisdiction. We here in Jamaica, we do not have that. And so it is really a matter of just the Cybercrimes Act and the offenses against the people that we can use. The ability to do that would take the process a long way forward in our being able to move without having the victim there. Because as it stands now, if you think you're a victim of a cybercrime, you must report it to a police station. You must get a record, a receipt for that report, and then it may be taken up by them or by us. If that initial report at the police station does not take place and there is a criminal undertone to the offense, then the individual is sent back. And oftentimes this is where the frustration comes in, when you look at the fact that if you just simply delete your email account, you probably don't have to deal with the issues. However, it really comes down to public education and awareness and the enforcement and deterrent capability of the law in treating with that. I don't think unless we change how we view crimes in our jurisprudence, we could move forward without the victim being present at some stage. Sir. As far as ethical hacking, the Cybercrimes Act, based on the definition of unauthorized access, would preclude that sort of behavior. Now, what we have recommended and are actively working at is, if you're a security researcher, or if you claim to be an ethical hacker, then if you think a platform or an internet-facing resource may be vulnerable, it is to reach out to the entity, to state your concerns, and to seek parameters within which you have the scope to do that sort of testing. And that then would, with the consent of the owner of the resource, negate the need for criminal proceedings to be considered at any stage. As our maturity in cyberspace and cyber incident response grows, though, sir, what we can have is a case where these entities, once the vulnerabilities are identified, now have either an innate capacity or access to the ability to remediate, because the challenge is whether or not you're going to get that ethical hacker to agree, if it's not a bug bounty type situation where they're being paid, not to disclose the vulnerability if they feel that it is not being A, dealt with expeditiously enough, or B, their work was not appreciated, or C, they just did it for the fun of exposing the vulnerability. So that level of maturity, I don't believe exists in our maturity model at this point. And so that is something that we would have to consider clearly going forward, sir.
Mr. Chairman, could I get a follow-up?
Sure, you can get two. Right, member.
Thank you. Lieutenant Colonel, you spoke about the deficiency in our legislation regarding being able to give directives to players in our jurisdiction who might be breaching either a criminal or facilitating a criminal offense, or even civil defamation. And the challenge of the cybersecurity is that it requires extra jurisdictional reach, because it is very easy, whether through pseudonyms or how hackers direct the path that they access you from, or somebody just who is sitting outside of your jurisdiction. They feel secure from the normal types of recourse that, say, a victim of defamation would have, or a victim of, say, even revenge porn, if the person was outside of Jamaica's geographic jurisdiction. Do we have any extra jurisdictional reach from the existing act? And if not, should we, when we look at the potential amendments flowing from your contribution, look at putting those in together with this ability to give the directives?
Chair, through you to the member, the ability to give these directives really would take us a step further along our maturity path. And what it would mean is that if, for example, Just Cert was to be advised by Singapore Cert that there is this 0-day vulnerability that is being actively exploited, now they're almost a day ahead of us, and we were to issue an emergency directive with respect to that vulnerability and its exploitation, then it would mandate that all entities in government and those in the private sector that manage national critical infrastructure or national critical information infrastructure must adapt whatever the recommendation is in order to mitigate this vulnerability. And that would then mitigate the exposure of these critical sectors and entities in terms of being susceptible to the exploitation of this vulnerability. So insofar as the legislation is concerned, if an entity in government is given that responsibility, then that entity would then be able to take a proactive approach to how certain vulnerabilities should be mitigated and how certain exploits should be remediated. And this would really set the tone for how the public and private sector behave with respect to the acknowledgement of vulnerabilities and their existence and the treatment of breaches. With respect to extra-jurisdictional reach, there are agreements in place that facilitate this sort of cooperation. Certainly within the Americas, there is what we call CSERTS Americas, which has Canada, the US, Latin and South America, and the Caribbean countries under the auspices of the Organization of American States, which allows for that level of cooperation. And where it involves a national of another country through the Ministry of Foreign Affairs and Foreign Trade, as well as MOCA through their agreements with law enforcement agencies across the Americas and the world, to include Interpol, can make these representation. Now, what it requires getting up to that point is the sort of analysis of the breach to ensure that what is presented is strong evidence that this national or this location in another country is where the attack emanated from. And so once we do that, there are those actual frameworks in place to facilitate that. We cannot get away from the trans-border nature of cyber. And so these partnerships, these frameworks are critical, and the more formalized they are, the better they are, so that they're not personality driven. So yes, there exists frameworks, and these can be strengthened through bilateral or multilateral agreements going forward, sir.
Thank you. I'm finished, Mr. Chairman.
Chair.
Thank you very much for that. Yeah. Is that Cavan?
Yes.
Go right ahead, sir.
Lieutenant Colonel, the impact of the pandemic, sir, it has created an expansion of the flexible work arrangement and more work from home. And this now would have created not only the more work from home by organizations and their employees, but it would have exposed the risk for work from home vulnerabilities for both the business and those employees involved. And especially so where some organizations might not have the infrastructural security arrangements for protection. Now, the first question I'd want to ask is that, has there been any report against criminal offenses in regards to this in regards to cybercrime since the pandemic that would have been related or aligned to work from home arrangements? That's the first question. And the second question is that, do you believe that the legislation would have to take this new proliferation into account in making provisions against any protection?
Through you, Chair, to the member, with respect to the additional exposure created by the modalities of work, particularly work from home, what we have seen is an increase in phishing attacks and spoofing attacks aimed at no longer specifically the company, but more so the actual remote node from which the worker is operating. What the phishing on its own is not really a crime as such if it's not reported. But what we're seeing is where the business emails are being targeted, and they're not targeting the lower level employees, they're targeting senior managers. The challenge we face with being able to give a concise or a comprehensive breakdown of the number of events is the underreporting. But certainly we have seen cases where individuals from whom have contacted their IT departments at work, who have contacted us, and we have been able to respond. What we're not seeing is the level of awareness of reporting these things. And there are methods that can be taken to mitigate these that does not necessarily require significant improvement in infrastructure. For example, if you have employees who have applied for work from home permission, then there are ways to check whether or not their wireless router at home is fairly secure, because it will never be totally secure, and whether or not the devices they're being given to do the task have been equipped with the necessary antivirus software monitoring capability to see that the device is not being broken into. And then there is the tunnel that you get back to the office from your home that is also being challenged. So there is an increase in the levels of attack against these remote nodes. What we have is a significant underreporting of these instances. With respect to the legislation, we are going to be suffering from the pandemic for a while, but it is really meant to be temporary. And so insofar as we're hoping to be out of the woods within another year or two, to write it into the law may be a bit much. However, as we seek to develop regulations around the act, we can do so and make this sort of considerations about the hyper digitization and the increased levels of cybercrime based on the dispersed modalities of this workforce in those regulations, which then could be easily changed without having to change the law itself again.
I thank you for that part of it, because under due consideration, what we have experienced is that outside of the pandemic, and because of the trigger of the pandemic, we are seeing more and more businesses investing in this flexible work arrangement. And so because it would have been triggered by the pandemic, and they would have recognized that it can actually work and maybe savings to cost in terms of operation, you may have situations now where employers are going to invest in this mobile operational modality. That would have been in the first instance triggered by the pandemic. So we might not get back to that pre-pandemic situation. And so maybe we have to take that into consideration into going forward, because it may very well become the new norm. But I thank you for your response and the insight in terms of the fact that we have not been getting the reports that would have been required to assist us. But thanks for your response. Appreciate it.
You're welcome, sir.
Thank you very much, member. Is there any other members that want to raise any questions or comments in relation to the just presentation? All right, Lieutenant Colonel Sterling, thank you very much. Very, very insightful. I think that takes us to the end of both presentations. I didn't get, as I said, the MSET presentation, but obviously I have it. And the just as we heard a while ago, was very insightful. So I think the next order of business now is in relation to the presentations, or to schedule the presentations. I just got a note earlier to say that both MOCA will be willing to present based on the extension. I would put it to the committee that the clerk can schedule those presentations based on the receipt of them. I don't know if we have gotten any responses or requests to make presentations. Can we be advised of that, please? Ms. Brandon, are you on?
Good morning, everyone. I have not received a request.
All right, and the ads were placed as was discussed at the last meeting?
Yes, Chairman.
All right, so based on the extension, we would advertise make that known through an advertisement, right?
Yes, Chairman.
So it's agreed that we would give the 2 weeks as of today, is what I had proposed earlier. Is that accepted by the committee?
No objections, Chairman.
Agreed, Chair.
Agreed.
All right, so there are some proposals for dates for the next meeting. There are 2 proposed dates for the committee to meet. Thursday, the 6th of May, or the 13th. The 13th of May at 10 o'clock. I don't know if there's any preference by committee members. That's 10 o'clock on a Thursday. Either May 6th or May 13th. I'm available for both. So unless somebody has a particular conflict, we can just decide on a date, whether it's the 6th or the 13th. Can I hear from the members if there's any?
I'm fine with both. These are virtual meetings, Mr. Chairman.
That's correct. That's correct.
The only other thing I would ask, I'm not sure of the full protocol for virtual meetings, but the committee clerk keeps asking that we turn on our cameras when speaking. And is the dress code for committees the same as it is for Parliament, or is that casual mode acceptable, given that many people are doing it from home?
Absolutely. As long as you're not by your pool, Mr. Bunting, I think everything will be all right.
Don't take casual to the extreme.
Just an interjection.
Some people,
Just an interjection, Chairman. It's still considered a formal meeting, although the meeting is virtual.
Yeah. All right. Well,
Meetings are carried live on PBCJ, so that's why we request that persons turn on their cameras when they're speaking.
Right, but what I was just asking, and I understand why you did, but I'm asking if, for example, business casual is adequate for the virtual meeting, or even if we're participating from home, we're expected to dress up in our full suit as we would if we were coming to Garden House.
Yes, Senator Bunting.
Okay. What is yes? What is yes? You'll be expected to dress in full suit?
Yes. Yes, Chairman.
Yeah. I'm glad you clarified it.
All right. Well, if that's what it is, if that's what the rules say, then I don't want to go against that. But I mean, I find it a bit overbearing.
Just to say,
right,
Chair,
so
just to say, Chair, that I don't know, whilst we would have gone and embarked on this modality, I don't know if there are any amendment of any such rules in the standing orders to make that determination.
Well,
so if that is the situation, you would have been in breach today.
Yeah.
But in terms of the dates, sir, I have no difficulty, and I think because of the competing interest in terms of various committees meeting, I think we should take the 2 dates.
Yes, I agree with that, and basically we can reach out without even the format of an advertisement. We can actually reach out to those persons and start to schedule them, especially those who have written to, so that we have presentations for both days, so that we can move the committee along. And just to say that I would like to check that Caban, because the truth of the matter is that even that cabinet is virtual, and you're requested to dress in a certain attire to cabinet, and it's not enforced in the virtual cabinets. So I think I find it a bit overbearing. But we'll check it out and see what is what, and notify the committee. So we'll take the both dates, and we will get presentations. We will schedule presentations, and that will be done through the committee. So can we confirm that and accept that?
Yes, I confirm and accept that, Chairman. Do you need a motion for the adjournment?
Yes, I just any other business. I think we've pretty much covered that. I don't know if anybody else has anything on the AOB before we a motion for the adjournment to the 6th, Thursday the 6th of May at 10 a.m. And then of course the follow-up meeting on the 13th, the week after. Is there
I would just like to thank the 2 presenters for a really informative session. I know you missed up some of it, Chairman, but I can tell you I really appreciated the thorough presentation, both presenters, and for non-technical people like myself, it was very, very informative. I just want to thank them, and if nothing else, I would move for the adjournment.
One sec, Member Bunting. Morning. Good morning, Chair. This is Hugh Graham.
Morning, Member Graham.
Yeah, and morning to the other members. Just to ask if the presentations will be made available or can be made available.
They were circulated.
I'm not sure if I missed it.
They were already circulated by email.
Okay, great.
Yeah.
All right, thank you.
Just check to make sure that they have the correct email for your member, Graham, so that because they are circulated both.
Okay.
Let me just say that I agree 100% with Member Bunting, especially for those, as you said, non-technical people. It is very easy to understand, which is critical, and to say that we look forward to the coming presentations so that we can take those inputs in and, of course, move the committee along to completion. So thank you very much for everybody, and see you on the 6th of May at 10 a.m. Be safe till then. God bless you.
Thank you.
Thank you. Keep safe, everyone.